Today's lesson will cover Chapter 4 on civil liberties. Many people often get confused the difference between civil liberties and civil rights. That is what you need to be able to make the distinction between. Civil liberties have to do with the Bill of Rights. It can be really confusing because civil liberties are rights. But when we're talking about the distinction, civil liberties and civil rights are two different things. Some of the major themes in this chapter include how the Bill of Rights came to be applied to the state governments through the 14th Amendment. Remember that originally the Constitution and the Bill of Rights was only to apply to the federal government. States had their own constitutions, often with their own Bill of Rights attached to them that protected individual liberties at that level. Over time, through the 14th Amendment, specifically the Due Process Clause of the 14th Amendment, cases started to come to the Supreme Court in which they ruled to hold states accountable to respecting these liberties as well. Another major theme is looking at the Free Exercise Clause and how that contrasts the Establishment Clause, both part of the First Amendment with regard to religion, looking at to what extent they may be exercised, at the same time how they may be limited. We will also be looking into civil liberties pertaining to free speech and criminal rights, as well as the limitations on each of those as well. So let's go over the difference between civil liberties and civil rights again. Remember, civil liberties are technically rights, but when we're talking about the distinction between civil liberties and civil rights, they are different. Civil liberties are constitutionally established guarantees that protect citizens, opinions, and property against arbitrary government interference. An example would be freedom of speech. Many people ask, what does the term arbitrary mean? Think of subjective. Think of someone making a decision by impulse, not relying on institutions or systems or principles. Civil rights, which will be covered in Chapter 5, is not with regard to the Bill of Rights. Rather, it is with regard to acts or legislation, policies that are passed in order to protect individuals from discrimination. So just to provide some other examples, with civil liberties, we can think of all of the liberties that are listed in the First Amendment. We can think of the Fourth Amendment, protections against unlawful searches and seizures. Those would be some examples of civil liberties, again, laid out in the Bill of Rights. Civil rights, on the other hand, might include the Civil Rights Act of 1964, protecting individuals in public accommodations from discrimination, as well as the Voting Rights Act of 1965, which worked against Jim Crow laws that were practiced in the South to keep African Americans from voting. US Americans are more inclined to give up their liberties when they feel like they're gaining a sense of security. This is most common during times of perceived threat or war. In addition, the Supreme Court has also upheld curtailments of civil liberties during these times as well. In contrast, though, during times of no perceived threat, citizens tend to believe that the government should interfere as little as possible. We can directly connect civil liberties to the Due Process Clause that can be found in not only the Fifth Amendment, but more specifically the 14th Amendment as it applies to the concept of selective incorporation and applying the Bill of Rights to the states. What is due process? Well, due process is the legal safeguards that prevent the government from arbitrarily depriving citizens of life, liberty, or property. When we look at the Bill of Rights, we can categorize them into four different areas. Amendment 1 deals with liberties that place limits on Congress. Amendments 2, 3, and 4 limit the executive. Amendments 5, 6, 7, and 8 are all limitations on the judiciary, and Amendments 9 and 10 place limits on the federal government. The key word is limit. Incorporation is a key concept you should feel comfortable talking about. The Bill of Rights originally only restricted the national government. Remember, it isn't until the 14th Amendment is ratified that it can be used to now hold the states accountable to respecting those liberties as well. Again, we can think of the concept of dual federalism, where we have sovereignty with the state and sovereignty with the federal government. So people are still considered both citizens of the state as well as the nation as a whole. Much of what we see in the Bill of Rights is very vague, which means it is up to interpretation. And through Supreme Court cases, we can better understand how the Bill of Rights is to be interpreted, although we still find those interpretations controversial to this day. The first attempt at the courts looking at the Bill of Rights as applying to states was in the case of Barron versus Baltimore in 1833. In this case, the court determined that the Fifth Amendment applies only to actions taken by the federal government. It isn't until the 14th Amendment is passed that strengthens the federal government's authority to hold the states accountable. In Barron versus Baltimore, Barron sued Baltimore because the city violated the Takings Clause of the 15th Amendment. Baltimore paved its streets, and because of that, the natural course of certain streams and the resulting buildup of silt and gravel in the harbor made his wharf unusable. Where the federal government would have needed to provide just compensation for that eminent domain, the states in the ruling of this court case did not. Fast forward to 1868 with the ratification of the 14th Amendment. It reads as if it were meant to extend the protections of the Bill of Rights to citizens' interactions with state governments. It specifically reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The Due Process Clause then is used to extend these liberties in the Bill of Rights to be respected by the states. And the Equal Protection Clause is what is connected to civil rights, which ensures that the federal government can create policies and legislation that protect individuals from discrimination. Now, the Supreme Court rejected the doctrine of total incorporation. Instead, they chose selective incorporation. What this means is that not all of the liberties that are within the Bill of Rights are then immediately applied to the states. Instead, through a series of incremental Supreme Court cases, in those decisions and in those rulings, through each of them, they will incorporate the individual amendments or even parts of those amendments to be incorporated to apply to the states. So they're happening over time rather than happening all at once. Take a look at table 4.3. You can find this figure in your textbook. We can look at selective incorporation of the Bill of Rights. It lists the amendments, and keep in mind that some amendments have more than one liberty listed. This means that Supreme Court cases may have incorporated only parts during given time periods or time frames. As you can see, almost all liberties in the Bill of Rights have been incorporated, but we can look at the ones that have not. Amendment 3 has not. No quartering of soldiers. Much of this has to do with the irrelevance. The United States is the largest military in the world with plenty of bases all over the country and the world. There really is no need to quarter troops in individual homes anymore. Other liberties not incorporated include the right to a grand jury in the Fifth Amendment, the right to a jury in civil trials of the Seventh Amendment, and lastly, the liberty to no excessive fines or bail in the Eighth Amendment. The Second Amendment is quite controversial, however, it has been incorporated several times. Many American citizens disagree upon the role of guns in a safe and free society. Is the right to keep and bear arms a personal liberty or community security? The textbook mentions a decrease in deaths caused by the use of handguns. In contrast to that, however, there has been an increase in mass shootings throughout the United States. This is where a lot of the conflict over to what extent the Second Amendment should be guaranteed when it comes to opinions of American citizens. Two court cases that were ruled upon quite recently have further incorporated the Second Amendment. In 2008, the District of Columbia versus Heller allowed individuals to have firearms for lawful purposes, and in 2010, McDonald versus Chicago required states to allow regulated citizen access to guns. Other things fueling the controversy over gun policies is to do with recent shootings leading to interest groups to call for stricter weapon laws. One of the largest special interest groups, the National Rifle Association, calling for more law-abiding citizens to carry guns to deter crime, and then also controversial stand your ground laws in some states have also been controversial because of the shooting of an unarmed Black teenager, Trayvon Martin. Many people have really pointed to how implicit bias is also causing individuals of particular demographic groups to be targeted by the use of excessive force. In 2015, states enacted carry laws that allowed licensed carry on public campuses and training for teachers and security personnel in schools. We can take a look at Figure 4.1, Concealed Carry Laws in College Campuses. All 50 states allow individuals the right to carry a concealed weapon. Only the District of Columbia prohibits it. After a number of campus shootings, some state legislatures have made provisions to allow the carrying of concealed weapons on college campuses. Currently, 23 states allow campuses to make this determination for themselves, and 19 states ban carrying concealed weapons on campuses. What regional variations do you see regarding these laws? Do you believe that increased access to weapons will decrease violence on campuses, or that it will heighten the possibilities for additional shootings? How do you think we can resolve this highly contested issue? Amendment number 1 includes 5 liberties, but we're going to focus on the freedom of speech, assembly, and the press. All of these freedoms are connected because they're essential for discussing issues facing the nation. These freedoms encourage consensus building, which is needed for democracy. We can see that these freedoms also lead to fundamental tension between protecting them and maintaining order. This can be seen through sedition acts, in the Lincoln administration, eliminating habeas corpus, which is the right to be heard in a court of law before entering custody, and during the Bush administration, subjecting individuals to military tribunals instead of running through the due process of federal and state courts. There have been times throughout history where we've seen a suspension of rights. In World War I, for example, the Supreme Court ruled that the clear and present danger warranted suspension of freedom of speech. We can see this in Schenck's pamphlets to resist the draft. Between World War I and World War II, the bad tendency test silenced speech that incited crime or disturbed public peace. This leads to the clear and probable danger test, which prevented free speech that was seen to threaten to overthrow the government. It was also utilized mostly during Cold War times to try to combat socialism. After the Cold War ended, the First Amendment becomes much more broadly interpreted. The Supreme Court determined that speech can only be silenced if, 1, it went beyond advocacy, and 2, it created immediate disorder or lawlessness. Currently, the imminent lawless action test determines that only speech that has a high risk of harm that's immediate can be silenced. This is perceived as controversial because speech that has bad intent is still allowed since lawless action isn't imminent. This means that hate speech or speech that comes out of white supremacists or the KKK is still protected.